Hello, everybody. Hello, Ava, baby. She's got to have her blue buffalo. Oh, my goodness. Hello. She is right up on me. Okay, you guys know how I am about supporting products that I really believe in or have a great experience with. And okay, so the last couple of months, I've been super self-conscious about my teeth. I drink a lot of coffee. Y'all know that. And whoopsies. Can I have that? Can you move? I've got to wait for her to finish her treat before I can get the box. Thank you. Now you can get your crumbs. So, anyways, I went out on a limb. I talked to my dentist first, and the stuff that they had was quite expensive. So I went out on a limb and I decided I would try this Colgate Optic White overnight. I've used it twice. Just twice. And I am no longer super self-conscious. It comes in this little, like, mascara type pen. And that's all of them. You get 3. So you brush your teeth and rinse, and then you take paper towel and dab them dry. And then you just take this little paintbrush and you paint your teeth, and then you go to bed. Next morning you wake up, brush your teeth, go on about your day. And this little pen it's got 21 treatments in it, and it works fantastic. It's actually made for sensitive teeth. So I have really super sensitive teeth, and that was one of my big things, because most whiteners will actually make your teeth more sensitive and cause like super extreme pain with hot and cold. This doesn't do that. So shout out to Colgate Optic White Overnight. I am so super grateful that for $30 I can confidently smile. And as you all know, this stream is not sponsored by Colgate Optic White Overnight. It's just something that I found that worked fantastically, and I wanted to share it with you guys in case anybody else is going through the same trauma I was. I really was. Like, I was doing this a little bit. Or I'd cover my teeth. Yeah. Coffee. And for a while I was doing tea. And let me tell you, tea stains worse than coffee. It does. But I now can drink my coffee confidently. Yeah. You're supposed to use it for 1 week or until you're satisfied. I've used it 2 days. I'll probably use it another day or 2 just to make sure. But it comes with 21 treatments in it. So put it on a shelf, and the next time that you need it, you've got it. Or share it with the hubby or the wife. You know. I don't recommend the dog or the cats, but You do you. Hello, Manuel. Woohoo, rain. I would not be looking forward to that because we are getting super cold, like borderline freezing. Hello, Nana Laura. It is, let's see here. Oh, I started sending C-Rex a text message and then I got distracted. It is actually 32 on the noggin. Yeah. And it's probably, let's see. Oh, it looks like it's going to be 32, 33 degrees all night long. Yeah. But it's not going to get much warmer than that tomorrow. Boo. Hello, C-Rex. Man, you guys talk a lot when I'm not around. Hello, Charlie. Hello, Eileen E. Carlin, honey. Hello, Spider-Man. Mine with this one, it still has the sores from my desk. So, these are absolutely helping, but it's, they've got to heal. So I keep, they're called hydrocolloid Band-Aids. They're like a thick gel padding, but they're a bandage and they just keep it covered and keep it cushioned. So I have those on, but like they roll and then the sticky gets exposed and then you got sticky gummy like cast off everywhere. So I put the big bandage over to hold the smaller bandages on, and it keeps the sticky stuff away. Hello, Linda Applegate, honey. Hello, Sandy Hurd. How you doing, sweetie? Here we go. Here's another one, a recommendation from Charlie. Clean Pro bubblegum flavor. $35 a tube, but it is a great toothpaste. Woohoo. I use what is the name of it? It was prescribed by my dentist. Carefree, Carifree, I believe. And so I use that. And then if like I don't know, I kind of bounce between Sensodyne extra whitening and the Carefree. I was really hoping the Sensodyne extra whitening would do the trick. It didn't. At least not fast enough. I'm very impatient. This very much pleased me. Hello, Builder's Wife. I am jealous. I'm very, very jealous. Hello, Credence and Mikey. Good to see you. Hello, Catherine Gaston. Yes, the AFC. Hope, did I miss Madam? I see a message saying, hey, madam. But I don't see her comment. Maybe she'll pop up. She'll pop up later. Oh, there she is. Hello, madam. How you doing, honey? Now that YouTube has changed all of your guys' names, I'm gonna have to like abbreviate and consolidate some of them and not do all of the numbers and extra words and things like that. There we go. There we go. Talk to your dentist. Dentists are your friends. They are. I love my dentist. I go to Deer Creek Dental here in Toma, and they're amazing. They're so great. I had 0 cavities my last appointment. And now it's gonna, okay, so this is gonna, I hate putting stuff like this out there because it just sounds bad, right? So the Carefree toothpaste, one of the things on the instructions, it tells you not to rinse. Tells you to put it on your teeth and just leave it. To me, that's icky. And my dentist was like, no. The reason why most toothpastes don't work to their full potential is because you rinse it out. And everything that's supposed to help your teeth, you rinse off. So he's like, if it really bothers you, brush your teeth and rinse, and then brush your teeth and don't. So that's what I do. I brush my teeth and I rinse, and then I brush them and I leave it. And if you use mouthwash, you're supposed to use it before you brush your teeth, according to my dentist. And considering I had 0 cavities on my last appointment, they were absolutely floored. Yeah. I think they might be onto something. You can also take like some of the whitening toothpaste and just, just put it on your problem area, your most open area, throughout the day a couple times. And that also is supposed to help. Just take a glob of it, rub it on your teeth, and go about your business. I do this kind of stuff. I do. Like that the whole, this stream is not sponsored by that actually comes from the fact that I do this so much. If I'm proud of something, like if there's a product that really wows me, I gotta share it with you guys, because I'm not the only one going through stuff. And if I can help even one person with something that they're struggling with, I feel like that's, my obligation in life. I don't know what you mean by the middle part there, but awesome. I don't like that. I don't like that. I don't like that statistic at all. Not a bit. All right, so tonight we have some really good in-person court hearings. I know, wild, right? I went back into the archive drive and I found some good stuff. This first one just blew my mind. It really did.
All right. Are we ready on Pearson?
Pearson. We're about to bring them out.
Okay, thank you. Madam Clerk, while we're waiting, can you give me that case number for Pearson?
Are you ready?
Yes.
is 2100625-01-FC.
Thank you.
Good morning, Your Honor. Erin Jan for the people, P78733.
Oh, no. We're not on the record just yet.
I'll just give
Yeah, I have to add it to the calendar, to the docket. I will be ready in just a moment. All right. I'm sorry. That case is ending in 625, correct?
Yes.
Okay, ready.
Calling case 210000625, People versus Andre Pearson. We're here for a motion hearing. Appearances, please.
Good morning, Your Honor. Erin Jan for the people, P78733.
Mr. Pearson, are you there?
Now keep your eye on Mr. Pearson. He's the guy in the middle in the green.
Yes, Andre Pearson.
Thank you. Mr. Pearson, I called your case back today because after inquiry, I realized that you were still in the Wayne County Detention Facility. And we tried to contact WC3 district to confirm your status as a student there, and to, more importantly, if you're enrolled, to find out what your class hours are so that I could fashion a modified bond provision. We weren't able to confirm that you are in fact enrolled in school. So that's where we are.
Judge, if I may,
Yes.
I'm sitting in the courtroom with Mr. Pearson. You know, I've been on the record with Mr. Pearson multiple occasions, and I know that the evidence and the testimony that was taken ultimately at the first trial revealed that Mr. Pearson has in the past suffered from a drug addiction or some drug issues. Mr. Pearson is acting physically right now in a way that I have never seen him act before, and it's really concerning to me, Your Honor. I'm wondering, and I don't mean to speculate, but I'm wondering if potentially he could be going through some sort of withdrawal. I don't know. All I know, Judge, is that his eyes are closed, he's shaking back and forth, and his head was down, and he was kind of bent over at the waist a little bit a couple of minutes ago, and there might be some sort of medical concern there. Respectfully.
Thank you. Thank you for bringing that to my attention. I can see Mr. Pearson, but I can't see those details. Mr. Pearson, can you hear me okay?
Right now, the deputy is encouraging Mr. Pearson to sit down, and Mr. Pearson is bent at the waist. His eyes are closed, hands are closed.
All right. So I think this is what we need to do. I think we need to get Mr. Pearson to the hospital right now. And I'm going to set another date for bond.
He did not sit in that chair. He literally just leaned, fell, and slumped.
Well, actually, I'll go ahead.
I'm sorry, I don't mean to interrupt this court, but now Mr. Pearson's legs are out and his eyes are closed, and the deputy had to help him to the chair. He looks like he was shaking a little bit.
Yes, I can see that. So I'm going to reinstate the house arrest bond, because even though I wasn't able to confirm his school status, it occurred to me that perhaps they weren't responding because of who was doing the asking, which is this court. And I don't know what their policy is. But Mr. Pearson, when we were last in court, seemed to be pretty comfortable with the idea of my confirming his school status. So I'm going to give him the benefit of the doubt that he is in fact enrolled in school. And I don't think I need to bring the case back now that I'm thinking about it. I can just modify the bond.
Judge, I think 911 needs to be called.
Okay, let's do that.
And Judge, while 911 is being called, I would ask that if he is going to be on house arrest, that drug testing be a part, regular drug testing be a part of the conditions of his bond?
Absolutely, that makes perfect sense, and you are actually reading my mind. I also want him to have an assessment, but I don't think that I can do that for a pretrial bond condition.
Thank you, Your Honor.
So we will have, thank you, we will have random drug screenings.
Oh, he's on the floor. He just had a seizure.
Oh my goodness. Golden,
Yes.
can you please contact court administration and ask if there is anyone here who has medical training, might be able to come and do a quick assessment of Mr. Pearson while we're waiting for the ambulance?
Okay.
Thank you. Okay, we're going to go off the record, but just to make clear, I'm going to modify the bond for the house arrest drug screening when he's released from the hospital. And I'm going to add that his hours for the house arrest tether could be adjusted based on verified school enrollment. Mr. Pearson, if you can hear me, we're hoping for the best for you.
Andre, stay with us.
All right, we're off the record.
Yeah.
He got a diabetic or anything?
He's a drug addict, is what he is.
He's going through withdrawal.
Potentially.
Maybe does anybody have Narcan?
Everybody see him step out. I need everybody in the courtroom. Let us handle this.
I'm wondering if there's someone in the building who would have a Narcan supply. I would imagine that this isn't the first time that this has happened in this courthouse.
2 days,
2 days.
and to my knowledge.
No,
Okay.
breathing.
That prosecutor has zero chill. When the deputy was asking, is he a diabetic? Her response was, he's a drug addict is what he is.
Judge, I'm gonna leave the courtroom. If the court would like anything from me, please let me know.
I will, thank you.
Ms. Golden, can you please provide me an update if you get it?
What's his name?
Andre Pearson.
I'm just gonna send information out to you.
207315.
You've been in jail that long?
He's been in and out, has it?
Yeah, that's it.
Did I hear the deputies asking how long Mr. Pearson's been in jail?
Yes, ma'am.
So that was on the 13th?
Of March, ma'am?
Yes. So just a couple of days ago.
His paperwork is over there. I had to grab him right when we did a move.
The one, where over where?
It's in registry. He was like,
It was an add-on?
yeah, they had him this morning. Yeah. So I ran over to grab him.
Madam Clerk,
Yes.
so I'm looking at the order that was
Yep.
entered on 313. The notes say that it was a reinstatement of the previously posted bond, but the actual PDF is that order that I entered allowing Mr. Pearson to obtain, well, to be able to have access to his phones at the police station. So can you correct that that note that says on 313 reinstate previously posted bond because I didn't reinstate the previously posted bond on
It's on your book.
on the 13th.
It was two. It was the him getting his.
Oh, I
Data.
see.
Yeah.
I see. They're just switched. I see it now. Okay. Thank you. Okay, so I don't know if Ms. Dan is still in there, but we already modified the bond for fair.
Because I try to just stay stressed.
So we entered that bond on the 13th, so I'm not really sure why he's even still in jail.
That's gonna come. Where they're waiting, if he doesn't need a calendar, anything else has to paper that says.
Do you understand what's going on with that, Madam Clerk?
Let me see.
Your Honor, there are more pressing issues at the moment.
Is it Pearson PER? It's only PEAR. You diabetic too? No.
Because actually, I think, oh my goodness. Let's see, emergency. Oh, looks like there was an emergency motion filed today. What is?
And get you some more. You want some more? Yeah.
Oh, I see you did. It is switched.
I'm really confused. So there was a motion filed this morning. Let's go back on the record for Pearson. Hold on one moment.
Dan, she had left. You
I
want me
know,
to-
that's okay. That's okay.
You want me to get her out the hallway, Your Honor?
She went back to.
Yes, if she is in the hallway.
I guess she went back to her office.
Okay. So maybe let's ask her to call on Zoom because she probably should hear this.
Just one moment.
I see Mr. Pearson is sitting up. That's a good sign.
Yeah, dehydration and so much, I guess, overwhelms.
Who's that talking?
That's Mr. Pearson.
Oh, good. Mr. Pearson, we're going to go back on the record for your case momentarily. We're just waiting for Ms. Dan to join us on Zoom, and I'm so glad that you've recovered from what was really a scary incident just now.
I did cut a lot of the space out where he was just sitting and there was absolute silence and nobody was moving. So this went on for around an hour and a half. It was absolutely crazy. But his excuse is that he was dehydrated and overwhelmed. And that's what caused the seizure and the symptoms that the prosecutor witnessed.
Thank you.
Okay, she's here now. So that's the case ending in 625, right, Madam Clerk?
Yes.
Okay. Okay, we're ready.
We calling case 21-000-625, People versus Andre Pearson. Appearances, please.
Good morning, Your Honor. Erin Dan for the People, P78733.
Thank you for jumping on so quickly. And I hear you putting your name on the record, Mr. Pearson. Will you state your name again, sir?
Andre Pearson for defense.
All right, thank you. Mr. Pearson, we recalled your case because you had a medical crisis while we were on the record just a little bit ago. I'm glad that you're doing better. I still think that you should be seen by a doctor. but
Your
I'm
Honor,
glad that you're
EMS
better now.
Well,
So I brought this case back today because
Your
Mr.
Honor,
Pearson-
EMS is on scene. Sorry about that, Your Honor.
okay.
Judge, my sound is really bad on my phone and my phone is literally about to die. Can I just come down to the courtroom?
Well, EMS is on the scene right now. Before they take Mr. Pearson, I just wanted to let Mr. Pearson know that I am releasing him today.
Yeah.
He'll have a house arrest with a GPS tether, but it can be modified by pretrial services upon verification of his school enrollment and class hours. We did try to confirm your school enrollment and class hours, Mr. Pearson, but no one responded to our email inquiries. And after I realized no one was going to respond, I brought the case back because I did not want to wait longer to reevaluate your bond. So I'm saying all of that to say that you'll be released today. Looks like the paramedics are attending to your current health situation. You'll be on house arrest at the address that we have on file for you. And you can go to school as long as you provide verification of your class hours to pretrial services. Do you understand?
Yes.
And Judge,
Now,
can
we
we
have
ask for a drug testing as well?
Yes, I'm glad you mentioned that. I'm going to put drug testing in the order. And that's going to be random drug testing, Mr. Pearson. And I want to be sure that there's no substance abuse issue that we need to address with you. This isn't by way of punishment in any way. Just want to be sure that you stay with it.
Well, it's not drug related, Your Honor. It's just only thing you'll find is.
Well, what I'll do then is I'm going to institute random drug screens. If after 2 they're negative, then the order will cease for drug screens. Okay?
Yeah.
Your Honor, how much is the bond, since you're not reinstating what was there?
So I am reinstating it unless I'm confused about what it is. I thought that the bond was $50,000, cash surety 10%, house arrest unless school hours are verified. Isn't that right? That's what I signed already, right?
Let me check again, because I'm thinking it was 25. Just one moment.
Well, it probably was, and I'm misremembering. By the way, we do have, and you should be aware of this, Ms. Dan, too. We do have a motion for reduction of bond that was filed this morning. I didn't notice it until we were off the record of when we called the case originally today. That was filed on Mr. Pearson's behalf by Mr. Cripps. Mr. Pearson, does that mean that Mr. Cripps is representing you in this case and you're no longer pro se or in pro?
Mr. Chris not representing me in this case, Your Honor. I'm still representing myself.
Well, how did Mr. Cripps file a motion in your case?
It might be from a previous motion that he filed last time.
I don't know if they've administered Narcan, if they've administered more Narcan or what, but a minute ago, you couldn't understand him. His speech was just so garbled. Now it's starting to clear up. So, I mean, they've done something with him. But I wish she would shut up and let them take him.
No, this was filed this morning. Have you spoken to Mr. Cripps since the last time you were before me?
No.
Well, maybe Mr. Cripps is your guardian angel and he filed this motion on your behalf. You should be aware of that because I'm going to give you my spiel about representing yourself. I'm going to make it very brief because you obviously are otherwise.
It's embedded in me already.
Mr. Pearson, please don't interrupt me when I'm talking. It's hard enough to communicate over Zoom, and I wouldn't want you to do that if I were sitting right there in the courtroom. You're going to have to get used to that. We can't talk at the same time, and I get really annoyed when people interrupt me. I'm advising you, as I will every single hearing that you come before me, that you should strongly consider allowing me to appoint counsel to represent you. And that's my spiel for today. See, it's been abbreviated. We're going to come back on, we already have a date set for trial in this matter, but we're going to come back sooner to see how the bond is working out. We have trial on April 15th. Let's come back in at the end of March.
End of March. March the 28th.
Mr. Pearson, does March 28th work for you, sir? Just to come back for a review so we can see, it's going to be a pre-trial. Make sure we don't have any outstanding issues before trial. Does that date work, March 28th?
Yes, it does.
Okay. And because it's a pre-trial, if you like and you are compliant with your bond, of course, you can appear via Zoom. You as well, Ms. Dan.
Thank you.
And I didn't ask if that date works for you, does it?
It's fine, Your Honor. Yes.
Oh, okay, so we'll see everybody March 28th at 9 a.m. And Mr. Pearson, take care of yourself, please, sir. Okay, we're off the record.
Now, most judges would have taken the video feed down. Not this judge. She's just as nosy as all of us.
Yes, please.
Up here.
Is he okay? Does he need any water? We have
We
water.
got him, so Judge. He's got water,
Okay.
Judge. Thank you.
All right, thank you.
So, okay. Say, Sarge. Can I have a word with you?
My first time doing this.
Mhm.
So who I did is I have one.
I wanted the deputy to meet you and try to come with you. Absolutely. First time.
Okay. So Madam Clerk, we entered that order already, so there's really nothing to do except to enter a separate order for, well, you know what, we do need to, we'll just modify the bond order. Not enter a separate order to add the drug screening, 2 drug screens, and if negative, terminate drug screens. That's all we need to add.
Okay. We'll probably leave, Judge.
Okay,
You want me to just do another order saying drug screening or?
Absolutely. Okay.
yes, same language as the one that we entered on the 13th, but, oh, and can you, while he's here, can we give him a copy of that order for it'll say the previously posted bond reinstatement, that order, let's give him a copy of that because that's the one he needed for the discovery to go.
Oh, yeah, yeah. Just slide it right underneath the mattress of the freaking ambulance cot. And then when he gets discharged, you can just put it with his discharge paperwork from the hospital. Oh my goodness.
Go to the police station and look at the phone content. So let's give him a copy of that and we'll modify the bond just to add the language, drug screening, random drug screening until 2 negative. If 2 are negative, then the drug screening will stop. So you just put it in whatever words you think work. You're pretty good at being more concise than me. Feel better, Mr. Pearson?
Just tomorrow.
Paperwork. Yeah. I know, but I didn't bring any paperwork. I didn't bring some back or whatever.
The EMTs can finally do their job.
Thanks. Yeah. We appreciate it. Here's an ensign, let's just think about the sake of that. What's that?
Madam Clerk, are APA Moore and Mr. Gozi in the courtroom? I can't tell.
No, they out in the hallway until they able to come back in. I'm
Okay.
emailing you the plea form.
Oh, we have it. Okay, wonderful. Okay, I don't see it yet. Did you already email or you're about to?
I'm about to, sorry.
Okay. No, take your time. I just thought you said you had, so I'm fine. No problem.
I just sent it.
What the hell's been going on? Fort Collins, they've been. They finally found me. We need numbers for, I'm 1573. Who the hell is that? Some other jackass? They're everywhere, trust me. No. He's a sick person sent out to the house. Nope.
Well, you know what? I'll just eat some real estate.
Yeah. Pearson. EARSON, first name's Andre. It's 20. 7315. Yeah, with the medic 6. All right, good talk, ladies. We'll talk to you soon, buddy. Bye.
Thank you so much. Does he have his order, Golden, for the phone
Yes.
access? Okay. All right, we'll see you soon, Mr. Pearson.
Oh, he's gone now.
Okay, good. Good. Madam Clerk, I think Mr. Pearson was right. I just noticed the date on this motion, and it was for March 15, 2021. But that's the last thing that's just a coincidence that it was today's date. I didn't pay attention. Yeah, I didn't pay attention to the year.
He done had a list of
Well, now Mr.
Attorney.
Pearson is thinking Mr. Cripps is his guardian angel. He may call to thank Mr. Cripps. And Mr. Cripps won't know what is going on. But oh well.
Did you get the email?
Yes. Oh, I'm sorry. I thought I said I did. I did. Thank you.
Okay.
And you're right, the bond was, we did change the bond to 25,000. I guess you can probably see that, but yes.
Yes. I'm switching it into Odyssey because I see it was confusing. The way the,
Well, I know it's in there though, so don't put yourself to any more trouble. As long as, but just make sure that the order that was for 313 stays in there so that the file properly reflects that the bond was actually changed on the 13th rather than today, and then we're modifying it today.
oh, okay.
Does that make sense?
Instead of just doing a separate order, you wanted me to,
Yeah, just
Like
keep
my-
everything that's already in there, already in Odyssey, just keep everything in Odyssey, even though the switching, that's not a problem. Just keep those as they are, and we'll do a separate order with all of the same provisions as the March 13th order, but adding random drug screens after 2 negative drug screens end.
okay.
FD.
And this is on today's pretrial.
It is, Your Honor.
Okay, just a moment. There we go. You are Mr. Franklin, is that correct?
Yes, sir.
I'm waving my hand. You can see and hear me, right?
Yes, sir.
And your attorney is Mr. Settles, is that correct?
Yes, Your Honor.
All right, Mr. Settles, we are here for, it looks like a plea hearing following pretrial today. And your client, this is, by the way, in file 24-14846FH. Your client is over in the county jail. He wishes to enter a plea by Zoom. The record should reflect that both defense counsel and the prosecutor have stipulated the same. I've agreed in this rare circumstance to allow it. What would you like to do today with regard to the plea, Mr. Settles?
Judge, again, on the record, what had happened is he's charged with the UDAA statute. Within the UDAA statute, there is a provision that the court may sentence essentially as a misdemeanor with 90-day max if this is his first time. And I think that's strictly up to the court. And the prosecutors agreed that that would be acceptable, and I certainly would like to do that. I've talked to Mr. Franklin about his trial rights and about he'd be waiving those trial rights, and he would like to do that too. This is the second time I've advised him of his trial rights, because I tried to do this downstairs in district court. District court was very uncomfortable with it because it's framed as a felony. But nonetheless, the second portion of the statute, I still believe is a misdemeanor. It does not require a PSI. Thank you, Judge.
All right, this is a Judge Hamlin case, so your client would also have to waive.
And he will do that.
All right, have to waive Judge Hamlin sentencing in this case as well, because it sounds like you intend to proceed to sentencing today. Is that what I'm
I would
hearing?
like to do that, and I know that I've spoken with Mr. Atwood. I don't think he objects to that. What? No?
All right, let me hear
Okay.
from Mr. Atwood, please.
I don't object, Your Honor, if the court's willing to do it. And just a slight correction, it's not the UDAA statute, it's the unlawful use or the joyriding statute.
Oh,
So as charged, it is a 2-year high court misdemeanor, which would be applicable up in circuit court. It's within the discretion of the court for a first-time offender to sentence the defendant under that statute for a 90-day maximum. I don't know that that changes the character of the statute as being a high court misdemeanor. It does change, obviously, the maximum potential jail sentence. So the court could handle it if the court wants to. I don't object to that resolution here, as he is a first-time offender. But as charged and as pled to, it would be a high court misdemeanor 2-year.
All right, so we need to make sure that your client understands that, sir. This is not going to result in a 90 or 93-day misdemeanor. But because he's a first-time offender, the conviction will still be for the high court misdemeanor, a 2-year max. However, the court's sentencing authority would be only up to 3 months.
Thank you, Judge.
All right, sir, do you understand the conversation we just had?
Yes, sir.
All right, do you wish to speak with your attorney about that, or you were able to hear us and you don't have any questions regarding what the maximum sentence could be in this case?
Correct, Your Honor.
Okay. All right, it looks like there's an offer that's been made in this case that would allow you to plead guilty to the 2-year misdemeanor motor vehicle unlawful use as charged. However, because you're a first-time offender, the maximum sentence would be no more than 3 months, so the prosecutor would not be arguing for a sentence in excess of that. The fine for same would be a maximum of $500. Knowing that, sir, do you wish to accept the offer from the prosecutor?
I do, Your Honor.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
All right, sir, you read and understand the English language, correct?
Yes, sir.
Okay, you can put your hand down. You can hear and understand me now, is that correct?
Yes, Your Honor.
Mr. Settles, as your attorney, you've had a chance to discuss with him the charges that have been filed against you and any possible defenses that you might have to those charges, correct?
Yes, Your Honor.
And you're satisfied with Mr. Settles' advice, true?
Yes, Your Honor.
Were you on probation, parole, or bond at the time this crime was committed?
No, Your Honor.
Now, do you understand this arrangement that I've discussed with regard to this? I'll call it a plea deal. That is a sentencing limitation. Do you understand what we've discussed, that the maximum sentence here is 90 days in jail?
Yes, Your Honor.
Have you had any drugs, alcohol, or medications that might affect your judgment in the last 24 hours?
No, Your Honor.
You understand that at each and every phase of this process, you've got the right to your own lawyer, and if you can't afford one, that I would appoint one for you at the published expense?
Yes, Your Honor.
Have you had a chance to review an advice of rights form, counsel?
Judge, I have not, well, he may have reviewed the advice of rights form down in district court, but I have not reviewed, I have reviewed his rights, yes, but not the form.
Let's go through it. Sir, you do have some rights. You're giving up. Those rights relate to trial. By entering this plea today, you give up the right to be tried by a jury. Has anything been promised to you, or have you been threatened or coerced in any way to get you to plead guilty?
No, Your Honor.
Is it of your own free choice and free will to plead guilty today?
Yes, Your Honor.
And are you doing so because you are in fact guilty?
Yes, Your Honor.
Let's go ahead and talk about what happened then. According to the information, you were in Traverse City on or about January 30th of 2024. And is that true?
Yes, Your Honor.
On that date, did you get yourself involved with a tan 2005 Jeep Liberty?
Yes, Your Honor.
You recognize that vehicle was owned by another person, specifically Tricia Martin, is that correct?
Yes.
Did you have authority to take or use that vehicle?
Yes.
Counsel?
Thank you. And you had authority to, I think you picked that vehicle up in order to change the transmission fluid for Ms. Martin, is that right?
Yes, and a few other things as well.
Another transmission problem case? People need to start just taking their vehicle to a professional.
Okay, and you were going to work on the vehicle at Safe Harbor and return the vehicle at 5 o'clock. Wasn't that the deal?
Yes.
And you ended up picking up someone else, didn't go, well, you may have gone to Safe Harbor, but you ended up going to the Pines and got the vehicle stuck. Is that correct?
Yes.
And then you called Ms. Martin and told Ms. Martin you would have it back later. It was stuck in the Fife Lake. Isn't that right?
Yes.
And that was not true because you were actually in the Pines at the time.
Correct. I said that in order to keep her from getting irritated or upset with me.
Well, she got irritated and upset nonetheless and called the police, and the police found you in the car at the Pines, right?
Yes.
All right, and you would agree that that was beyond the authority that you were given for that particular car?
Yes,
Thank you. I think that satisfies it.
And sir, you haven't been convicted of unlawful use of a motor vehicle before, is that correct?
that is correct.
All right, any additional questions regarding a factual basis for the defense?
No, thank you.
For the people?
No, satisfied, Your Honor.
Do the parties believe the court has complied with MCR 6.302?
Yes, sir.
Yes, sir.
All right, sir, it's now up to you. As to the charge that you did on or about January 30th of 24 without authority and without intent to steal, take, or use, that you were a party to such unauthorized using or taking of a motor vehicle. That is a 2005 Jeep Liberty belonging to Tricia Lee Martin, contrary to Michigan law, that being a 2-year high court misdemeanor in Michigan. How do you plead?
Guilty.
Well, based on our discussion, it's clear that you understand your right to counsel. It's clear that you understand the rights you're giving up by taking advantage of this plea agreement. And it's also clear that you violated the law in the manner that we discussed. Parties have discussed going directly to sentencing. In this case, I'm going to go ahead and grant the request to do so. Is there any claim for restitution, or is there a victim in this case?
I don't think we have either here, Your Honor.
All right. I suppose I should ask whether the victim has been communicated with in this case and wishes to participate, or is at least aware of her rights as a victim.
We have definitely made her aware of her rights as a victim, and I don't believe she's requested those rights here, but I'll double check, Your Honor. No, we have not heard that.
Okay. All right. In that case, do the people have any argument regarding sentence?
No, Your Honor, thank you.
Let's go ahead and hear allocution, please.
Judge, he's been in jail for 46 days on this, on a 90-day offense. I would ask the court to sentence time served. And he doesn't, his record is not wonderful, but it certainly doesn't suggest that he should be doing more time on this charge. Back in 2014, I think he was sent to prison for a burglary. It's an older record. Okay, here we go. 2022, he may still be on probation. In 2022, out of 88th Circuit, Montmorency, he had a misdemeanor controlled substance use with 24 months of probation. I think that's his last bit. Before that, it's operating while license suspended. And I have operating while license suspended 2018, 2020, and then this 2022. The 4-year bit, I think that was out of state somewhere, and that was a long time ago. And that was a burglary case back in 2013, Judge. And he ended up, looks like concurrent 4 years. I guess he had 2 charges, 4 years imprisonment. I'm not sure out of what state. There you go.
Okay, any additional argument, Mr. Settles?
No, Judge, I would ask for time, sir. Thank you.
All
More
right.
importantly, what I think.
Mr. Franklin, is there anything you wish to tell me before I sentence you in this case, sir?
I messed up. I know I messed up. I apologize to everybody in the matters of this case. I have been given information about my children, so I'm supposed to be gathering my children and starting to reunite with my family again, as well as soon as this case is resolved. Other than that, I plan on doing everything by the book from here on out, and I also have work as well as soon as I am released.
All right. The question before the court is the sentencing of Mr. William Franklin. Mr. Franklin pled guilty to a 2-year high court misdemeanor involving motor vehicle unlawful use. However, because this was a first offense, the court is able to sentence him to no more, if I agree to 3 months in jail and a fine of not more than $500. The court is going to go ahead and do so. The defendant does have a criminal record. It is not insubstantial and does include some years ago a prison sentence, and then a series of other misdemeanors, primarily involving motor vehicle matters that caused me some concern, frankly, and certainly would result in some kind of jail sentence under a conviction like this. However, I do think that the amount of time that he served being 50% of the 3-month maximum that is suggested by the legislature is proportionate, consistent with the way he presents himself and the seriousness of the case. I will go ahead and sentence him to time served. There are some fines and costs. There is a $50 state court cost, a crime victim's assessment, the amount of $130. He's going to have to pay, what's the misdemeanor attorney fee? He's going to have to pay $500 in attorney fees and a local court cost, the amount of $150, a fine of $100. All of that will be payable to the circuit court. Make consistent payments over time, and you won't have any problem.
And the next time somebody asks you to fix their car, actually fix it and don't just take it on joyrides and then lie to them about it.
If you avoid it, pretend like it doesn't exist, hope it goes away, there could be a warrant for you and you can be back before me, and I don't want that to happen. I'm sure you don't as well. So you
No,
do
sir.
need to communicate and take that amount seriously.
Yes, sir.
Is there anything else that we need to address in this matter today, Mr. Sellers?
No, thank you, Judge.
And for the people?
No, Your Honor, thank you.
All right, sir, we're going to forward to you an appellate notice. You do have the right to appeal your conviction of the sentence you've just imposed. You also have the right to the assistance of an attorney to prosecute any appeal that you wish to take. If you can't afford an attorney, one will be appointed for you at the public's expense, should you choose to appeal. But if you'd like to appeal, you'll need to sign the document we send over, submit it to the court, to your attorney, to the jail within the next 6 months, or that appeal is waived. You understand, sir?
Yes, sir.
All right. Anything else for the record for defense
No, thank you very much, Your Honor.
and for the people?
No, Your Honor, thank you.
All right, sir, we'll process the paperwork. You should be out here shortly.
Thank you again.
Thank you, sir.
Okay, I think we've got time. Hopefully we do one more. Let's go back to the people, please.
Thank you, Your Honor. Next up is People versus Wallace Petrosky Jr., file 23-14634 FC.
Okay, Mr. Petrosky, I'm holding up a copy of the pre-sentence report. You've had a chance to review this with your attorney, Ms. Missel, correct?
Yes, Your Honor.
I would note that I've also received the communication from Catholic Human Services and the letter that you wrote me on the 15th as well. Ms. Missel, are there any changes that you wish to propose to the body of the report or any challenges to the scoring?
No guidelines, objections with regard to the corrections on page 1. The credit for time served, I believe, should be 93 as opposed to 92 days. There were
Any position with regard to that?
No, Your Honor.
All right, we'll go ahead and set that at 93 days based on the agreement of the parties. Ms. Missel.
Thank you. Also on page 1, the end date for the alcohol use, for some reason it's stated twice, alcohol, but the end date would be the same, 12/17/02.
All right, without objection, that change is made.
I would also ask that that same correction be made, or addition rather, on page 18 under substance use and treatment.
That change is made without objection.
And then finally, in terms of changes or objections, at the very bottom of page 1, under evaluation and plan, it's a sentence that reads, additional concerns for this defendant include a history of homelessness and numerous indications defendant is associated with drug dealing in Pines. I'm objecting to that and asking the court to strike that. Mr. Petrosky adamantly denies it, and there's absolutely no record evidence to support that statement. It is based on, I don't know what, assumptions apparently.
Let's go ahead and hear from the people as to the last sentence in the last full paragraph on page 1 of evaluation and plan.
Your Honor, I'm not certain where that came from either, so I would not object.
Well, I had actually underlined it and I was going to ask some questions about it, so that saves me some questions. We'll go ahead and strike that, given that there is no apparent basis for it, at least in the report or this report, so that matter is struck. Your next issue.
I have none, thank you.
Thank you, Ms. Missel. Let's go to the people. Do the people have any changes they wish to propose to the body of the report or any challenges to the scoring?
I have neither, Your Honor.
All right, any argument with regard to sentence?
Just to support the recommendations here, Your Honor, this is clearly a prison case in my mind, at least. defendant has a horrible record. He has been in trouble going back to the mid 1970s. Has been in and out of supervision. To say he's institutionalized, I think is an understatement. Not somebody we want or can supervise in our community. He's productive. He's not been a productive member of the community really in his adult life. He has done horribly on supervision in the past. He's done horribly on bond in this case. He absconded, was picked up with more meth, running from law enforcement. He has a history that includes larcenies, violent sexual assaults, drug dealing, OWIs. It's just, at some point, we have to stop banging our heads, realize that we're not going to be able to help Mr. Petrosky. We've tried for the last 4 decades, but have been unable to do so. So to me, I think a sentence near the top of the guidelines is appropriate. We've expended enough resources on him and his rehabilitation over the last 40, 50 years. And I think that prison is the place he's accustomed to and frankly, the place he belongs given his behavior in our community. Thank you, Your Honor.
All right, thank you. Let's go to you, Ms. Mistley, allocution.
Thank you. At first blush, that may seem like a reasonable argument that Mr. Atwood has just given to you, but I suggest that we need to look a little deeper into this. There's no question, of course, that Mr. Petrosky has a very lengthy record. However, I think it's notable his last violent offense was back in 2002, at which time he quit drinking. We have no violent offenses since then. And he tells me on the date of his arrest in that 2002 CSC case, that was his last drink of alcohol. Now, I know that the Department of Corrections doesn't believe that. And they state in the PSI on page 16 that, you know, obviously he was drinking because he was arrested for open intox in a motor vehicle last autumn. But what the writer either did not know or simply omitted to put in this report, Mr. Petrosky had borrowed that vehicle from another homeless individual earlier in the evening to drive to the 7-Eleven to get a cup of coffee. He did not know there was an open container in the vehicle, and it certainly was not his. At the time that the police had contact with them, he pleaded with them repeatedly to give him a PBT, and they would not do it. So Mr. Petrosky maintains that, again, he was not drinking. He hasn't had a drink in over 22 years. He did everything he could to show that to law enforcement. They refused to assist in that. And he tells me that had that case not been dismissed as part of the plea agreement in this case, he fully intended to take that case to trial. In terms of the prison guidelines of 29 to 57 months in this case, those are based on his prior record going back to 1978. The offense variables are 0. 0. So the entire reason for the recommendation or the guidelines is his prior record. He's been to prison. He has served his time. He has paid his dues. But now it's being suggested he needs to go back to prison, not because of this case, but because of everything in his past. He's gone to prison. He's gone to prison again and again. And here we are. I am suggesting to you, perhaps this time we ought to try something a little different. The reason there are 0 points in this case, because of the factual background, as I know you're aware of, he did offer to provide a small amount of methamphetamine, and I believe it was $40 in exchange for consensual relations. He ends up being the victim of a false report made to law enforcement. Now, of course, she has not been prosecuted for falsely accusing rape. And now he's looking at prison as a result of what happened with him and his longtime so-called friend. And she's wandering the streets, continuing to wreak havoc. It was interesting to read in this police report, and the court may have picked up on the fact that as soon as she called Central Dispatch that night, they knew exactly who she was, and law enforcement knew exactly where to go. But rather than us spending as taxpayers $40,000 a year to send Mr. Petrosky back to prison where he will not be provided any services because of the number of times he's been there, and he learned that the last time he was in prison, perhaps that money would be better spent at TRICAT, where he's in a 24-hour supervised setting. He gets cognitive therapy, he gets help for the mental health treatment, and he gets help for the substance abuse issue that he obviously has. He tried for a lengthy period of time before this case arose to get help from our local CMH. You don't qualify, you don't qualify. So in order to deal with the mental health issues and the PTSD, he did what many folks do. He turned to street drugs. And here we are. Now it's being proposed. Let's waste more taxpayer dollars, send him back to prison. Nothing will be accomplished. He'll come back out. He'll still be mentally ill. He'll still have cognitive issues, and he'll still be a substance abuser. Let's try something different. And that's supported by Catholic Human Services. I know the court read the letter from Ms. Rodzinski. The court, I'm sure, also read, I had forwarded a copy of the letter from the jail chaplain. Yep. And I believe that Mr. Petrosky wrote an extraordinary letter. Extraordinary. I did not assist in that. And not that it really matters, but I think Traverse City Public Schools and then St. Francis did well by him. His penmanship is gorgeous. Let's try something different, Judge. Thank you.
All right, thank you. Well, Mr. Petrosky, I've read the report, obviously. I've listened carefully to your attorney. I've also read the materials that were provided, including your lengthy letter to me, and I agree with your attorney. It was very thoughtful. I've listened also to the prosecutor in this case. I'd be glad to hear from you now before I sentence you, sir.
Yes, Your Honor. I mean, just to address a couple of the concerns that were brought up about whether I'm drinking or not drinking. I don't drink anymore. I stopped alcohol a long time ago. My friends all know I don't drink. I was in error because I did borrow somebody's car without doing my due diligence. Now, I should have checked to make sure the guy lied. I asked him, says, "Is the car legal? It's got tags, plates, insurance, everything's cool." Yes, he lied to me. I used the car, went to the store once. A few hours later, he asked me to go to the store again. Went to the store again, had a problem because it's a high interdiction area. And, they pulled me over. And I explained to them that the contents of the car are mine. I was surprised as they were when they found some alcohol on the passenger seat or underneath the seat or wherever it was. I didn't know. I didn't look.
I'm not concerned about the alcohol. I want you to know. I want you to focus on this matter because I accept your statement at face value that you haven't consumed since 2002. I'm willing to accept that for purposes of sentencing today. So you can go ahead and proceed.
The thing I want you to know is I've had a lot of trouble in the past. I recognize that my record's poor. I've been working constantly. People don't realize it, but I've had a lot of work trying to understand what makes me do the things that I do, and I'm really trying to make myself better. Like literally, I don't like being like this. I don't like being embarrassment to my town, my family, my friends. I don't like being like this. And I'm doing everything I can to heal myself. I literally, nobody asked me to go to CMH. I did it on my own because I knew I needed to because of my PTSD. And I knew I needed to find some sort of legal alternative to illegal drugs that I was using to keep myself on an even keel. You know what I mean? Literally. And I did everything and I was accepted as a client there. I just haven't had a chance to go follow through with the treatment plan, to develop the treatment plan with my caseworker. And the most amazing thing to me is like everybody in the community, like I would never expect Like there was a time when you said, oh, I was gonna go to do some drug rehab or some education or some cognitive therapy program. I'd have been like, you're nuts. I'm not doing that. But I recognize I need the need for it, you know? And I'm trying to do the best I can. Like, I just have to keep putting one foot in front of the other every day and do something positive. You know what I mean? And I wrote a short statement here, you know, because I have cognitive difficulties. And so I wrote it down and I could read it to you if you want, or
You're welcome to read it. Just please read slowly so we can go ahead and make sure it gets in the record.
I mean, I have a lot of problems because I get too many concussions. So at one time in my life, I lost the ability to care about myself for a long time after all the years of prison. During those years, people I thought were my friends and who I thought loved me turned their back on me. In turn, I didn't love myself much.
It's amazing how many friends you lose when you stop drinking or stop doing drugs.
But I'm learning to care about me again, in large part because of total strangers who began to show me love. I will, going forward in a positive, proactive manner, tackle my homelessness because I understand that homelessness places me into contact with negative, risky behavior personalities. I will do everything possible during my initial recovery period to minimize this through maintaining a job and cultivating more positive, pro-social friends. I will keep trying to explore the reasons that underlie my actions. For example, what thoughts and feelings preceded my relapse this time? I will continue to use safe coping skills and realize that I'm the author of my life. I'll create a new positive lifestyle for myself. I have to. And I will think of the consequences of my actions before going forward, before I make decisions that can impact my life or the lives of others in a negative way. And I will utilize my community support system. I will always defer to members of my community support system because they have much more experience in recovery than I do. Any advice as to treatment or medications I need to incorporate to keep my life on track.
We know exactly what drove your behaviors this time. It was a bag of white crystals and a little blue pill.
I will surrender my life to a higher power and commit myself to that guidance humbly and willingly with gratitude. And I'd just like to add that my mother is 96 years old. And my stepfather is dying now. So she has trouble with mobility. And I'm really the only person who doesn't have much of a life. If something happens, they need to go there and take care of her. I always promised her that I would. She took care of me my whole life, even when probably wasn't worth taking care of. I wasn't much of a son sometimes, you know, a lot of times. My father worked for the city. You know the story. I just want to be there for her. It's more important to me than anything. I mean, I'm important, but that's more important to me than anything. I just want to have a chance. If something happens, that I can go and help her, because she helped me all my life, and I feel like she has that help. You know, definitely. And it just, I don't know. Sorry, I'm getting really emotional right now. My anxiety's pretty bad, and I just want to make myself better. That's the bottom line. Like literally, I just want a chance. Somebody to give me a chance. It's not going to be really any skin off anybody's, you know. I'm going to go and I'm going to do the right things, or I'm going to go to prison. It's pretty simple. Or I'm going to go to prison and get out and do the right things. You know what I'm saying? But I just really feel like prison is why my PTSD is so bad now. And I'm trying to deal with it. I'm trying to work with community mental health and everything I know of as far as resources in the community. And the more and more that I reach out to people, the more and more love that they're showing me, and it's really helping me on a mental level, you know what I mean? So I just want to follow through and have a chance to do the right thing for a change, you know? And so like something that my mother could seize on at the end of her life and say, you know what? At the end of it all, he kind of got it together. That's all I'm looking for.
All right, thank you, Mr. Petrosky. Before me is Wallace Petrosky. He's a 62-year-old man. He was here with his attorney, Ms. Misteluch. He was appointed in this case. He's before me because he pled guilty to creation or delivery of an analog controlled substance. It's a 15-year felony here in the state of Michigan. He has 93 days that he has spent in jail that will credit against any sentence that I impose. His bond was revoked. He's been held for a period of time now. There are a series of other charges that were filed, and along with a fourth offense habitual offender notice, the court is dismissing those now pursuant to the plea offer in this case, along with two district court files, 23-0421 ST-1 and 23-0875 FY-1. The defendant comes to us with a very serious record. His attorney is absolutely correct. He's really here before us on a substantial potential sentence in prison because of his prior record. His PRV total is 130 points. That's a PRV level F, and it's awfully difficult to avoid prison when you get to PRV level F. It's based on a record that goes back to the 1970s. His first adult conviction was in 1979 and continues out throughout the last 40, 50 years. When we look at the last 10 years, that takes us to 2014 when he was convicted in May of a controlled substance delivery violation and habitual offender second offense notice. He was sentenced to the department in that case. He was released at one point and engaged in intimidating behavior when he was released. He was returned to prison for that and other matters. He was paroled again. He was found to be positive for methamphetamine. There were some other issues with regard to his homeless status. Ultimately, he was returned to prison again. This time related to willfully violating sexual offender registry notice requirements. In 2019, he was convicted of his compliance reporting duties under SORA. He was sentenced by this court to 14 to 24 months in prison. We had a similar discussion at that point, and when he was on parole in that case, he was found to be in possession of methamphetamine. Ultimately, he was discharged in 2022. That brings us to this current case. He did bond out in September of 23, and then he wound up with this open intox case. The court's willing to accept that the alcohol that was in the vehicle was not his. He didn't get a chance to try that case, so I'm not going to hold that against him. But he was released on bond in January of 24. There were several violations. He failed to test. This is someone who's considered an expert in the system. He knows what his requirements are, but he failed to test. He failed to appear in district court, and his bond was revoked. In 2023, we had the open intox case that was dismissed, and then there was a charge for possession of meth, resisting and obstructing a police officer in November of 23. That was dismissed pursuant to plea as well in this particular case. This case involves him trading or offering to trade a certain amount of money and drugs in exchange for sexual relations with the party identified in the report, Ms. Lauren. There was a point at which apparently Ms. Lauren did not want to proceed. There was a I don't know, hold on, let me stop there, where she didn't want to proceed, and ultimately the matter was reported to the police. When the defendant was brought into contact, he did have in his possession what he called SIM cards, but in fact, it was found to be a pipe. He indicated that he was self-medicating at the time. And my belief is that it was ultimately determined to be 1.5 grams of methamphetamine. The guidelines in this case are 29 to 57 months. I don't think those guidelines are proportionate. They certainly are reflective of the seriousness of the case, I think, but not reflective of the criminal history. The criminal history of this defendant is substantial, certainly, but this, I think I said that backwards. They may be reflective of the criminal history of this defendant, but they're not necessarily reflective of the offense that was committed here. It was a rather low-level offense, given the kinds of things that this defendant has been involved with. However, the defendant has, through his activities over the years, made it very difficult to avoid a prison sentence when he is involved in any criminal activity. In fact, I think that discussion, I've had that discussion in the past before, if memory serves. So he's absolutely entitled to a prison sentence. However, a prison sentence in the amount of 29 months is excessive in this court's opinion. The court's going to sentence him to, just a moment, to 16 to 180 months in the Michigan Department of Corrections. He has credit for 93 days that he has served. There is a $68 state court cost of crime victims assessment in the amount of $130. No other fines and costs in this case. I want the defendant in the best position possible when he does ultimately get out of jail. I recognize this is a departure sentence. As a departure sentence, obviously either party has the ability to appeal. However, I do believe that the downward departure is appropriate, as again, while the defendant certainly has a criminal history that supports prison, the actual crime here was relatively innocuous given the amount of drugs involved and given the report's indications with regard to the participant in the consensual sex and her presentation as well. Again, this is a sentence that's resulting largely from the criminal history that this defendant evidences versus the actual crime. I think it's proportionate at 16 months. Any questions with regard to the sentence for the defense?
None, thank you.
For the people?
No, thank you, Your Honor.
Sir, I've handed your attorney a document that outlines your appellate rights. You do have the right to appeal the conviction of the sentence I've just imposed. You also have the right to the assistance of an attorney to prosecute any appeal you'd like to take. If you would like to appeal, you need to sign that document where indicated, turn it into the prison, to your attorney or the court within the next 6 months, or that appeal is waived. Do you understand?
Yes, Your Honor.
All right.
Thank
Counsel?
you, Your Honor. For the record, Mr. Petrosky has initialed his notice of appellate rights, and I've returned the original to the court.
All right, thank you, Mr. Petrosky. Good luck to you, sir.
Yes, sir.
Holly?
He took that well. 16 months. Oh yeah, he took that very well.
Cases 2300-507601 and 2300-508001. People of the state of Michigan versus D'Angelo Deron Jackson. These matters are scheduled today for sentencing and pretrial appearances. For the record, please.
Good afternoon, or good morning, APA Larry King for the people, P78774.
Judge, good morning to you and good morning to your staff. Michael Woodyard, my number is 64612. I'm a staff attorney at Neighborhood Defender Service in Detroit, and our office represents Mr. D'Angelo Jackson. He's here in court. Would you say good morning, sir, and say your name?
Good morning, Your Honor. D'Angelo Jackson. Good morning. Counsel for the people, sir. Have you an adequate opportunity to review both the pre-sentence report and the sentencing guidelines?
Yes, Judge.
Any additions, corrections, deletions, factual changes to either of those documents?
No, Your Honor.
Counsel for the defense, sir. Have you an adequate opportunity to review both the pre-sentence report and the sentencing guidelines with your clients, sir?
Judge, we have reviewed the documents.
Any additions, corrections, deletions, factual changes to either of those documents?
Your Honor, as to the pre-sentence report, I believe we have no amendments or corrections to make. And I do think that the sentencing guidelines are correctly scored as provided by the.
Mr. Jackson, sir, have you an adequate opportunity to review both the pre-sentence report and the sentencing guidelines with your attorney, sir?
Yes, sir.
Any additions, corrections, deletions, factual changes you wish made to either of those documents? All right, counsel for the people, go ahead, sir.
Your Honor, this is a case where sentencing was set over because when we were before the court initially, the complaining witnesses, who are both here, brought to my attention that after the plea in this case was entered, the defendant sent Miss Monet Johnson, one of the complainants, a message through a jail messaging app. The people have looked into this. We received official records from the jail. I've provided them to defense. I have requested this be marked as People's Exhibit 1. I've moved for the admission of the court to the court today.
Any objection, counsel?
There's no, Judge. No, I would note that there's no certification attached. However, this is in the nature of a kind of an evidentiary hearing, so I know the rules don't apply. So I don't have a legal objection.
Okay. So we can have the court reporter mark that as People's Exhibit number 1 and admit it into evidence.
I've already requested court reporter, Madam Court Reporter, mark this before we went on the record, so I would move for its admission and request it be turned over to the court.
All right, then that'll be admitted as People's Exhibit number 1.
May I approach?
Yes, thank you.
So, Your Honor, approaching, handing this to.
Okay.
Your Honor, this case involved a plea agreement. As part of the agreement, there was a no contact provision. People's position is that the defendant has violated the terms of his plea agreement and therefore should no longer receive the benefit of his bargain plea agreement. I would move to invalidate the plea agreement under MCR 6.310. The complainants are here. They can address the court if the court wishes to have testimony. I do think they want to be heard regarding sentencing. The idea behind this plea agreement was that the 5-year statutory term of probation would be more beneficial than the prison term, which were dictated by the guidelines. But I think it's clear by the fact that the defendant continues to reach out to the victim that probation really isn't appropriate, Judge, and I would ask that the court vacate the plea agreement and impose a term of prison within the guidelines.
Counsel.
Judge, Mr. King's arguments stand only if the court accepts as true the notion that this document in front of you accurately reflects Mr. Jackson's conduct. I think that there's ample reason to question whether or not it does. I would point you directly to the document for the base of my argument. You'll note that this printout purports to represent communications from Mr. Jackson's, I don't know what the name of it is, but it's an app of some sort that folks who are incarcerated in the jail have access to communicate with people on the outside. So the document purports to represent Mr. Jackson's communications on that app for a 1-month period from February 28th through March 28th. And you'll note that in the course of 1 month, apparently, there were 5 messages sent within 3 minutes of each other on one date. Mr. Jackson, if you ask him and place him under oath, will tell you that he did not send these messages.
You know, and let me ask the prosecutor, who produced this document?
Officer Solberg, Wayne County Sheriff's Department, our jail liaison. I can get him on Zoom to testify. I can also produce the complaining witness to testify to receiving this message and how she received it. And
Right.
I will also.
But this actual document, I understand she indicates that she received it, but this document that you handed me that's been marked as exhibit number 1, a Wayne County Sheriff produced this document?
Yes, produced by Solberg.
Wayne County Deputy, I mean.
Deputy Solberg, yes.
counsel, do you have any reason to dispute that?
No, not at all. In fact, was admitted with the caveat that it reflects an official record.
So just so I understand your concerns, if a Wayne County deputy sheriff says he produced this
Yes.
from your client's account,
Yes.
what's your worry? What's your concern that he didn't do this? Or what proof do you have that he didn't do this?
Sure.
Go
Sure.
ahead.
So I think that the circumstantial evidence suggests that it's suspect that Mr. Jackson sent it because of the timing and because of the idea that in the course of a month, there's only these 5 messages on his entire communication list, right? So suddenly somehow in 3-minute period on March 26th, 5 messages were sent from his app.
You are not in any way indicating that this wasn't sent on his app.
No, it was sent on his app. That's apparently true. My issue is there's no evidence that Mr. Jackson sent it. And is what he will say if the court places him under oath and asks.
And we can do that. We can put him under oath. Would
Okay.
you like to do
Yes,
that?
please.
Would you
I'd
like to?
I'd like to.
Why
ask
don't we
Mr.
have him sworn in and
Yes,
you
please.
certainly are free to ask him any questions?
Perfect.
Okay.
Mr. Jackson, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this matter now pending before the court will be the truth and nothing but the truth, so help you?
Yes.
Great. Sir, can you state your name for the record?
Yes, Jack.
And can we kind of have you move over a little closer by the microphone there? Both of you are going to need to be close to it. So, all right, counsel, go ahead with your question.
Thank you, Judge. Mr. Jackson, on my computer screen, I have a copy of a document that has been marked and admitted in front of the court as Exhibit 1. Can you see this document?
Yes.
Have you and I looked at this before?
No.
Okay, have I talked to you about this document before?
Yes.
And did I tell you about the date of March 26th on which these messages were apparently sent from your account in the jail?
Yes.
What did you do after I told you that?
Filed a grievance.
And what is a grievance?
It's basically like.
Is it a complaint with the
It's
sheriff's
basically a
department?
complaint.
Okay.
Basically, somebody stole my PIN code. Like they use PIN codes and they don't need like the face to recognize the person. You can point it towards a wall and it'll log you in.
So after you filed a grievance, what was done?
When they changed my PIN code.
Okay. Was this the first time that your PIN code had ever been changed?
Yes.
Did you send these messages?
No.
Your Honor, that's all the questions I have for Mr.
Counsel
Jackson.
for the people.
So, Mr. Jackson, you're familiar with Rakia Gandhi, right?
Yes.
And you've in fact had numerous conversations with her and video chats with her, correct?
Yes.
But it's your testimony that you did not message her on 3/28 requesting that she accept your video visit?
No.
And would you be surprised to learn there was a video visit with her and you with your face appearing on it at the Wayne County Jail on that day?
No.
Okay, so you did have a video visit with her on that day?
No.
You did not?
No.
The counsel indicated the 28th of March as the premise of this question.
Right. Okay. Yeah, but you've had video visits with her on numerous occasions.
Yes.
And repeat the name, counsel.
This is Rakia Gaydon, Gagnon, Gagnon, represented by items on this list.
Spell the first name.
Rikki.
Wait, items on this list.
Yeah, the ones that aren't highlighted. I'm talking about the ones that aren't highlighted first.
But you're saying March 28th. Where's March
Sorry,
28th on
26th.
this?
26th. My eyes
Oh,
are.
all right, because I
March
thought
26th.
there was a sustain. All right, let's go over the questioning again because I'm completely confused.
So on March 26th at 11 o'clock, did you message this person, Ricky Gagnon, asking for a video visit?
Yes.
Okay. So this message here, the one sent at 11:02 on 3/26 to Miss Gagnon, you sent?
Yes.
Okay. And are you familiar with a Matisha Collins, MITASHACOLLINS?
Yes.
Okay. And have you had video visits with her in which her face appears?
No.
Have you had communications with her at the jail?
No.
Did you communicate with her on the 26th of March?
No.
Have you had communications with Miss Monet Johnson using a jail application in the past on previous occasions?
Yes.
And her contact is a contact information that's known to you, right? It's saved in your account, correct?
Blocked.
It's blocked in your account.
Mhm.
Okay, but it wasn't blocked before March.
And the name again, counsel?
Monet Johnson.
Okay, all right.
But it wasn't blocked prior to March 26th, correct?
I'm not sure.
And this is a person that you've had numerous communications with throughout the years over many different methods, correct? And you are familiar with her family, correct?
Yeah.
You know her father, correct?
Yeah.
But it's your testimony that you did not message her and speak about her father and talking to her, on March 26th. Now, you have to have a secure PIN to access this device to send these messages, right?
Yeah.
So your testimony is that you did send a message to Miss Gagnon at 11:02, but you did not send a message to Miss Johnson at 11:04?
No.
Okay. Anything else? Counsel, anything to do?
No, Judge.
Is there anything else you want to add to your argument, counsel?
No, Your Honor.
Okay,
No.
you've made your argument.
I've made my argument.
All right. Is there anything that Mr. Jackson would like to say with regard to the argument, if you agree for him speaking, counsel, if not, you know what I mean? With regard to this issue, is there anything he wants to add? I'm going to give him an opportunity to speak with regard to the sentencing later, but just with regard to this issue.
Thank you. Mr. Jackson, do you have anything else to say about this specific issue?
No.
All right. Counsel, is Ms. Johnson here today?
She is.
Could we have her placed under oath with regard to this issue?
Do you want her in the jury box or witness stand, Judge?
She can come up here to just up to the jury box if everybody's agreeable. Is that fine? Is that fine with you, Mr. Wood?
Of course, yes.
Okay. All right. We can have you stand up by the microphone. Thank you, ma'am.
Sorry, Judge,
Yeah.
my fault.
Yeah, that one.
Okay.
Yep. Oh, I'm sorry. Okay.
Yeah.
Okay. Ma'am, can you state your name for the record, please?
Monet Johnson.
All right, and if you could spell that for the court reporter, please.
Yes. MONAY Johnson, JOHNSON.
Okay, counsel, go ahead.
Ms. Johnson, how do you know?
Oh, I'm sorry. Let's swear her in.
Ms. Johnson, please raise your right hand. Do you solemnly swear that the testimony you're about to give in this matter now pending before the court will be the truth and nothing but the truth, so help you?
Yes.
Thank you.
And Madam Clerk.
How long have you known the defendant, Mr. Jackson?
And counsel, can we have you come around to the
Oh, I'm so
microphone?
sorry.
Thank you, sir.
Thanks.
Okay.
15, 16, young,
And you're how old now?
29.
Fair to say more than 10 years? And throughout the 10 years you've known him, have you communicated with him via text message on a regular basis?
Yes.
Does he know members of your family, including your father?
Yes.
And you are the complaining witness in the stalking, one of the stalking matters that are before the court today, correct?
Yes.
Have you communicated with Mr. Jackson while he's been incarcerated in the past? In jail?
In the past, yes.
Okay. And how did you communicate with him while he was in jail?
Through the video app, the Getting Out app.
Okay. And that Getting Out app is an application that interfaces with the Wayne County Jail and allows you to communicate with him, correct?
Yes.
And was there a time that you had set up an account specifically to speak with him?
Yeah.
And how long ago was that?
I was like, yes, I would say probably since 2020, 2021.
And he was incarcerated in a different matter at that time?
Yeah, yes.
So throughout the years that you've known him, have you received messages from him using the Getting Out app?
Yes.
And those messages, how do they get to you? They come to your phone?
Yes.
But you have to launch a specific app to get to them. They're not like
Yeah.
text messages,
Yeah.
right?
Yeah.
And they say his name, correct?
Yes.
And did you receive a message from Mr. Jackson's account using the Getting Out app on the 26th of March this year?
Yes.
Okay. And I'm going to show you what's been previously marked as People's 1. Look at the message body, if you will. Do you see that?
Yeah.
Is that the message that you received from the defendant's account on March 26th?
Yes.
Now, you've talked to him many times over text messages, correct?
Yes.
Are you familiar with the way that he communicates his language, the way he talks?
Yes. If I may speak on something,
Oh, wait, what did you say, counsel?
All
right, let's do this question and answer, please.
Question and answer for now, and we can get to that later in a minute.
Okay.
So this begins with you, weird ASF. Has he ever used that language with you before?
Yes.
And is that consistent with the way that he communicates?
Yes.
He references a new person that you have in your life. Did you have a new person in your life at that time?
Yes, I do.
And he references your father, referring to him as yo dad. Did he, to your knowledge, was he familiar with your father?
Yes.
Has he referenced your father in messages before?
Yes.
He's clearly a poet.
And there was also a message in here. You know who I am and how I operate. Has he ever used that language with you before?
Yes, sir.
May I approach the witness and
Yes.
ask a question off the record?
No, yeah, you can't.
Okay, I just wanted to see, I wanted to make sure that whatever she wanted to say was something that make sure it wasn't anything I needed to delve into at this time. So I didn't want her just to say it on the record, but I wanted to see if it was anything I needed to delve into.
Yeah, no.
Okay, then I'll pass the witness for this time.
All right.
Thank you, Judge. Just very
Okay.
briefly. Ms. Johnson, you have this app, installed on your phone?
Yes.
So when you receive a message, it just shows up on your phone, correct?
It goes through my Gmail.
Through your Gmail, okay. There's not a video call component to the message? Like you didn't get a call and alert and have a video pop up on your phone or anything like that?
No, it doesn't work.
Okay, all right. And you didn't have a video call with Mr. Jackson on March 26th, is that true?
No.
Okay. So you, might sound funny, but you didn't see Mr. Jackson sending this message to you, is that true?
No.
Okay. It's not true, or you
I didn't see him.
Okay, all right, thank you. I don't know.
Counsel?
No follow-up.
All right. Do you want to go, I'm trying to figure out how to handle, do we need to discuss this anymore other than in your arguments on sentencing? Can we handle it that way and go ahead and have her and the other young lady give any statements? Is that agreeable doing it that way, or do you want to have some argument before we go into that.
May the witness have a seat, Judge?
Yeah, she can have, why don't you sit down right there, ma'am, for right now? So counsel, would you rather do some argument and then have them give statements, or?
I would rather do some argument.
Okay, all right, go ahead.
Your Honor, we have.
And counsel, before we do that, is there anything else you want to put on?
No, Judge.
Okay, all right, go ahead.
So, Your Honor, this is a secure system used by the Wayne County Jail. We know that he's communicated with this system to the complaining witness in the past. The two have a long-standing relationship and had numerous communications, some of which are the basis for the stalking case that brings us to court. The content of the message, especially in light of the testimony of the witness, speaks to the fact that the defendant sent it. Using turns of phrase that she's familiar with, speaking as though it's him, referencing a new relationship that she's in, referencing her father, which is a person known to him. All of that on the face of this message alone supports a finding that the defendant in fact sent it. Adding to that, the fact that it was sent using a secure system from the Wayne County Jail, using his account to her account as illustrated by these records, only 2 minutes after a message to another person that he admits to sending. All of that just goes to show that this is authentic. I understand the defendant is denying it, but his bold-faced denial is just not supported by the weight of the evidence.
Okay, thank you. Counsel for the defense.
Judge, I point out that the only direct evidence about who sent this comes from Mr. Jackson. Under oath, he says that he didn't send it. I think it's highly unusual that, as I pointed out in my earlier observations, that through a month of texting or messaging on this app, that the only 5 messages that he sent or that were sent from this account were on this particular day in this particular 3-minute window, which would support our contention that somehow somebody got a hold of his PIN number or a hold of his account and sent out messages to people who were on his contact list. Again, the only evidence that direct evidence of who sent this is from Mr. Jackson, and he testified he didn't.
All right, well, first of all, we have evidence with regard to this, that the document that's been marked as People's Exhibit number 1, that Deputy Solberg created that data and provided the prosecutor with that data. So the court is going to find that, at least as far as the conveyance of the information on the Get Out app, this was set, and I don't think anybody was sent that way, and I don't think anybody's disputing that. The Get Out app, he has a secure PIN number with regard to that. Miss Monet Johnson indicates that she had to agree to get that on her phone and to have that come in on, so she had to put that app on her phone, which is consistent with her receiving that information. It's fascinating to the court that the argument that, so he admits that on March 26, 2024, 11:02:02, he uses this secure app and sends an individual named Rikki, spelled RIKKIGHGNON, says, accept my visit for Wednesday. And yet, approximately 2 minutes later, someone else gets a hold of this same device and sends an email or sends this secure text. You weird ass, I'll be home to see you and yo dad and that new nigga you got. I don't know if you forgot, but I'll remind you who I am and how I operate. Well, interestingly enough, the complainant in this matter indicates that he has used those terms in the past, which I can't say everybody I know calls somebody you weird ass, but she says that he says that, and that he knows her father. He's familiar with her father and has referenced him in emails before, that he talks about that there's a new person in her life and he knew about that, and that he also has used as a term of art before with her that reminds her but I'll remind you who I am and how I operate. And he wants me to accept as a rational person that he didn't send it. He has been charged and convicted. He's pled guilty to stalking. This is classic stalking behavior. And I'm not going to rely on that with regard to my decision. His defense is so ridiculous. I've been doing this since 2007, and I don't know that I've heard such a silly defense. But I am going to definitely find that he sent these messages to this young lady. So go ahead, counsel.
So, thank you, Your Honor. And again, do you address the court at sentencing at all?
If you want to say something now as far as the sentence, this is your opportunity. You don't have to speak, but if you'd like to, now is your opportunity. Would you like to say anything with regard to the sentencing? No? All right.
Over if you want to address the court for sentence.
And if you don't, ma'am, you can have a seat. If you want to speak, ma'am, you can come up to the microphone now.
Ms. Holbrook is the other complainant in the case. Microphone.
Stand up.
And if you can, yeah, there. If you can just state your name for the record first, please.
Okay.
Ma'am.
Angel Holbrook.
All right, and ma'am, can you spell that for the court reporter?
Yes, ANGEL HOLBROOK.
Okay, thank you. Whenever you want to, you go ahead. I'm going to ask that whatever you have to say, you say it to me and not to the defendant.
Perfect.
Okay?
Okay.
Okay, go
So,
ahead.
I would like you to take into consideration the history and the years that Monet Johnson has been going through domestic violence, the advocates that we have, the medication for anxiety that she's on, the constant counseling that we're going through, the panic attacks that has taken a toll on her medical well-being, not feeling safe in her home. I've moved her 4 times because of this individual. He has threatened explicit death threats to myself.
And are you two related?
Yes, that's my daughter.
Your daughter.
So I'm
sorry.
constantly helping
Okay.
and taking her and doing things for her. But when I receive explicit death threats to my home, and I have to have the Taylor Police SWAT team watch my home for 2 weeks and have to go stay in a hotel because the death threats are so explicit, and then threatening my 13-year-old son. This has been an ongoing thing for like over 5 years. She has been with somebody else for quite some time, and he keeps coming back to the same house. I feel anybody who will mock the police department and the court system and keep coming back after they were giving multiple opportunities and then play hot and cold with the Taylor Police Department has no respect for authority. And I asked the court, how many times will he receive a slap on the wrist, even after stabbing Monet's father 7 times for protecting her under a domestic violence situation?
Now, was that stabbing part of this case?
No, it was a different case.
It was a different case. Okay.
Yes. So this has been ongoing like over and over again that the family has to endure over and over again. I could not physically move her into another house again and again. We've moved 4 times. Property damage that's not noted, windows broken out, cars just trashed for no reason. My home, my tire slashed out. Him demanding that I let him in back in her house. I mean, I just want the court to take into consideration if somebody is sending explicit death threats, to me, that's premeditated. Look at Oxford, for example, the Oxford shooting. We didn't take that seriously. My child rides and he is with the Oxford High School students in the equestrian team. Nobody took these mental, threats and writing seriously. And then we have kids that died. We have people that are getting murdered every day because we don't take it seriously. I had a friend just recently at a restaurant that was in the news. She worked super hard. She opened a restaurant. One of the chefs made advances, and he ended up stabbing her to death in her apartment. because she refused to try to fire him. So where do we draw the line? So that's what I would like you to take into consideration, and also Monet Johnson's mental health and the child, because now his child is going to receive counseling as well for witnessing all the abuse. That's all I have to say.
All right, thank you very much.
Okay, thank you.
Thank you.
So Your Honor, I'll give the court a little insight into what I was thinking when I put the offer in the case together. And that is this: the 5-year probationary period was mandated by the aggravated stalking statute, would have allowed our office to tack a lot of terms and conditions onto this case and keep the defendant under supervision for an extended period of time in hopes to rehabilitate, alleviate the situation. But I think all of that's kind of gone out the window because the defendant has demonstrated that even after pleading guilty, he is continuing this pattern of behavior. So, Your Honor, I think it's appropriate under the court rules at this time to not follow the sentence agreement. And the people would request that the court send the defendant to a term of prison commensurate with the guidelines. I don't believe that the original offer remains appropriate in light of the new behavior.
Okay. All right, counsel for the defense.
Judge, I appreciate the court's attention to this. I would often remind.
Can we have you come around the microphone?
Of course,
Thank
yes,
you, sir.
yes. Judge, I'm often reminded about how important it is that when the state brings its power to bear against an individual, that the prosecution of that individual is handled by people who are professionals. And I say this with all due respect to people who have been victimized or by the conduct of others, but the court knows that many of the things that were mentioned are not necessarily appropriate considerations for a sentence. That said, Judge, we did enter into an agreement, and while the court has made a finding as it relates to this document, People's Exhibit 1, it's our contention that the sentencing agreement provides the best path forward and is appropriate in this case. And specifically because of the things that Mr. King has mentioned, that is that for a 5-year period, Mr. Jackson will be closely, and I say closely supervised. There are a raft of very intrusive and encompassing conditions that Mr. Jackson must follow according to the agreement. It seems as though, based upon the conduct that's reflected in the plea here today, that Mr. Jackson may benefit from that type of intervention. It's an intervention that, if the court follows what the prosecutor has urged, and simply sends Mr. Jackson to prison, washes its hands of the whole thing, it's an intervention that will not be made available. And I think that in this particular case, it's appropriate. I'd ask the court to follow the sentencing agreement.
Okay. Mr. Jackson, this is your opportunity to speak to the court before I impose sentence. You don't have to say anything, but if you'd like to, now is your opportunity, Mr. Jackson. Is there anything you'd like to say? And again, you don't have to speak, but if you want to, now is your opportunity.
I just want to say, I've been going through this for a long time. And I thought it'd been over in 2020 when I came here. I went home. I got into a real boyfriend. Got into it. Went down there on Tether. I had left her alone. And I changed my life. I enrolled in school. Supposed to graduate this June. For the National Adult Education in South Bend, Michigan. I have a daughter, 7 years old. CPS just got called on her mother.
Anything else?
And I just wanna make sure my kid is all right. My son's not doing that good in school. He's going through trauma. Seeing this guy come in, that guy leave.
Yeah, kids really struggle when they don't have a father in their life because their father has gone to prison. Shocker.
I just feel like I need to be there for my kid. Not just for myself. So,
Okay, I want to ask both you and your attorney, do you remember when I took the plea that I indicated at that point in time that if you violated that I would not be bound by the sentence agreement? Do you remember that? Counsel for the defense, do you remember me telling your client that?
Judge, I know that that is something the court says at every time. I don't have an independent recollection, but I know you say that.
All right, Mr. Jackson, do you remember me telling you that?
yes, sir.
Okay, all right. Then the court, I don't normally do this, but I think this case cries out. I had indicated to the defendant that with regard to this aggravated stalking, that if he violated, that I was not bound by the terms of the sentence agreement. And I am not going to be bound by the terms of this sentence agreement. I am looking at this. I've looked at the facts of this case. The sentencing guidelines for the minimum are 19 months to 38 months, and the court understands it is no longer bound by sentencing guidelines. I can give a sentence less than sentencing guidelines. I can give a sentence within sentencing guidelines, or I can get more than 38 months. I think that the sentence that I'm about to set forth is rehabilitative, it's proper punishment, it's deterrent effect, and the court understands it's not bound by the sentencing guidelines. I believe that the fact that the defendant has pled guilty to aggravated stalking, that even after he pleads guilty, the brief period of time that he's waiting to be sentenced, that he sends to these people, to Monet Johnson, a note that says, "You weird ass, I'll be home to see you and your dad and that new nigger you got. I don't know if you forgot, but I'll remind you who I am and how I operate."
And the fact that he mentions the dad who he stabbed 7 times, that's scary. It's almost like a threat of, I'm coming back to finish the job.
This concerns this court a great deal, because it's very clear he's setting forth. If somebody tells you you're going to do something, pretty good factor in this mind that they're going to do it. You better believe what they say. The defendant repeatedly stalked these both of the complainants in this matter. The original stalking included messages where Jackson tells Holbrook to watch her back and tells her that someone worse than me is coming for her. She believed that he was threatening her life and safety. She believes that Holbrook stated she believes that he's texting her because she's related to and mother of Monet Johnson. The officers had to be out to Ziegler multiple times in the past several days due to threats against Johnson from Jackson. The texts she had received were sent via email to Detective Johnson in a video recording where it said, her being next with a hatchet emoji, don't leave your son home with a devil emoji, the cops can't stop me, your daughter is dead than you. Call the police, I will kill you. Now Monet, the blood that slides out her throat. Monet is going to die. Angel, you know what death feels like. I watched the police move your car. Angel, I know you are connected, but you know what is more connected is a bullet with your name on it with emoji winking, crying, laughing devil. I see you are not home. I will see you after work. Don't be scared. You're going to die. If I see one police car today, you will be sorry. I will kill myself and everyone, bitch. Your daughter had going to be on a silver platter with yours, bitch. Your daughter is about to die, bitch. I hope Randy come home so I can stab him. You seen how I slash your tires, your throat next. You're next. I can't wait to see the blood comes from your neck. I, Angel, how you like to die, slow or fast. You know I was living there. I bugged the house. I seen the lights go out. I see Jesse look out the window. I'm going to kill you and Randy. Watch. I see everyone gone. Listen to this now. It's about to be a gun with a gun emoji. I'm at Mini house in the background. You can't find me. I just broke their window. I seen KD. I should have hit him. You is next. My people will kill you. Now it's time to strike. I'm there. I haven't been seeing you pick my son up for school. So if y'all keeping my son from going to school, I'm really gonna kill you because I got a close source across the street and they tell me everything. So when my son go to school, I'm gonna get him. I want my son, Angel. I want my son. And they have a child together. With regard to his adult history, he has 19 different charges originally. But he wasn't convicted of all of them, but he was originally convicted of replica firearm. He's placed on probation, but then on August 12, 2014, HIDA revoked that during a violation of probation case. He also had a conviction for resisting instructing a police officer, was placed on probation, but that was revoked and probation closed. He was convicted of trespassing, operating without a license, domestic violence, children contributing to delinquency of a minor, aggravated domestic violence, operating without a license, domestic violence, second offense note, assault with intent to do great bodily harm less than murder. So the severity of his assaults become more and more violent. Failure to display a valid license, lying to a police officer. So the court is going to, I'm not going to follow that sentence agreement based upon the reasons that I set forth. And I've given you the reasons for my sentence also. I'm going to order that he serve a minimum of 36 months to 5 years in the Michigan Department of Corrections. He is to receive 92 days jail credit served. He is to have anger management while he is in prison, and he is also to have mental health treatment. He is to pay a crime victims assessment in the amount of $130, $1,300 court costs, attorney fee of $400, $68 state costs, and he is to have DNA testing and pay the mandatory $60 fee. If both counsel can approach the bench for a moment, if you can come around, yeah, don't go behind her.
It was 270.
270? We agree.
270. Yes, I think it was 270. Yeah. Since original case.
So what's the total amount of jail credit?
1 more. Yes. Judge, we discussed very briefly off the record, the jail credit is incorrect as noted.
All right, why don't we have you come around to the microphone?
Oh, thank you.
Because nobody asked for that to be changed, so.
Yeah, and that's my mistake, Judge.
All right.
We believe that the jail credit is appropriately
270 days plus one.
Well, give me the total amount.
14, 15, 16, 17, 18, 270, 289.
I would agree. This is based on previous conversations.
All right,
and
so I will
research.
change the jail credit to 289. And then that'll be changed on the first page. And then also on the, where the Department of Correction recommendations is, I'll change that to the 289.
Thank you.
Okay, so he'll receive 289 days jail credit served. Sir, you may file an application for leave to appeal your conviction and sentence. If you choose to do so, you must do so within 42 days. If you cannot afford an attorney, the court will appoint an attorney and furnish the attorney with portions of the transcript and record necessary to handle your appeal. This request must be made within 42 days. The court has considered your ability to pay as outlined in the PSIR, and as indicated earlier, I'm ordering court costs the amount of $1,300. This sum represents the costs associated with the prosecution of the defendant in this matter, including salary and benefits for related staff, goods and services for the operation of this court, the necessary expense for the operation and maintenance of the courthouse. Sir, I'm further advising you that the request for the appointment of an attorney must be made in writing and filed with the clerk of this court within 42 days. You're being handed a form through your attorney inquiring into your financial condition, requesting such appointment, and I request that you sign the receipt for that form. I again remind you to file that form with the clerk within 42 days of today's date if you intend to appeal and are unable to afford an attorney. Fines, costs, and other financial obligations imposed by the court must be paid at the time of assessment, except when the court allows otherwise for good cause shown. A late penalty of 20% will be applied to attorney fees and court costs that continue to be unpaid 56 days after the date of sentence. Failure to pay may result in state tax intercept, wage withholding, license suspension, probation and or parole violation and or referral to credit bureaus. Counsel, is there anything else we need to take up with regard to this matter?
Nothing further from the people. Thank you, Judge.
Judge, I will note that Mr. Jackson executed his acknowledgement of appellate rights. The court has a copy.
Okay, and then is there a second case that's being dismissed? Is that correct?
Yes, Your Honor.
Okay, then I will sign that order dismissing that case. Is there anything else we need to take up with regard to Mr. Jackson's case?
There were two lingering charges on this file also. So there were two charges on this file to be dismissed and also another.
All right, anything else?
No.
No.
All right, nothing further. This matter is completed. Everyone have a nice day.
Thank you, Judge.
Thank you, Your Honor.
All right, thank you.
I don't know how anybody can be expected to have a nice day knowing that the likelihood is he's out right now. Because this case was from a year ago. He's going to get good time credit. He had already served nearly a year. So that means that he'd be running really close to his minimum of 3 right now. So unless he got himself in some more trouble in the jail. I agree, but that's what they do with plea deals, you know. They always drop something. In this case, I think it was the ball. I could not believe when the judge started reading the messages and you really got a sense of what that mother and daughter had to endure. I couldn't even imagine for it being that bad. So, anyways, I hope you guys liked the compilation of cases tonight. No. You shouldn't be near anyone's kids at all, ever. He'll just indoctrinate them into. Oh, I meant to click on this one. I don't know. Did I? I think I accidentally had clicked on this one. I don't know. If you can't tell, I'm tired. I had to take the medicine because the jolts were getting really, really bad. So. Me too. Me too. Yep, that's exactly where he's going. Heaven doesn't want him, and hell's afraid he'll take over. Maybe he'll spend the rest of his years in limbo. And yes, thank you so much. I'll be honest, though, I don't really post on the Instagram. That was an Auntie M thing, and then Auntie M got busy with her life, and I don't even know the password to it. Or the password to the recovery. I need to do some digging. What you doing? How comfy was that recliner, Mortimer Duke? Where you been, babes? Missed you. Oh no! Be ready to scream at the screen. It was Judge Mark Slavens, not Judge Joseph Slavens, that's on suspension. Judge Mark Slavens, that stopped streaming a while ago. She's inside. When I went potty, I got her, brought her back in. She's up on the bed in the other room, taking up the whole dang thing until I get there. Yeah. So you know those plastic tidy cat buckets? That's what I keep to scoop the cat poop in, and then I just dump it into the garbage bin. Well, it had some rainwater collected on the lid, and that was ice this morning. All right, you guys. Thank you for coming and hanging out with me. I hope you had fun. I know I did. As serious as some of those cases get, you guys keep me sane through them. Especially that first one. Ooh. I have a feeling there's going to be a couple people from my channel that send strongly worded emails or letters to the judicial system about that. I'm not advocating for doxing people, but yeah, I'm not going to stop anyone who wants to tell the judge how they feel about that mistreatment of that man. I don't care if he was on drugs. EMS was there. 911 was called. At that point, stop the dang hearing. It's no different than the guy that we watched a month or so ago that had the withdrawal seizure in Payson. And the judge just, I'll get the paperwork over to you. as we were watching the guard's elbow go up from doing chest compressions on the poor guy. It's like these judges are so disconnected from the fact that it's a human being that they have standing before them. And that's sad. Well, I don't really think, okay, so like doxing would be like putting her address and phone number out there. And I don't want that. I don't want people going to her house with, pitchforks and torches. But sending a letter to the Judicial Committee, told you I took my meds. That was on public record. That was a hearing held for people to see. We saw. And if people didn't like what they saw, there are professional ways to handle it. There are professional levels of the Judicial Committee that you can contact. It's no different than if you saw it playing, straight from her channel and not on my channel. Like I said, I'm not for doxing people. I don't want people showing up to her house. I don't want people calling her. I don't want people making threats against her or anything like that. But taking a professional route, if someone perceives misconduct, okay. The legal system has routes to do that, appropriate routes. And I'm not going to look down on anybody. I'm not going to tell anybody to do it, but I'm certainly not going to stop anybody if they feel it necessary over a judge's misconduct to take one of those avenues. Yeah. Oh, absolutely. But she was, like I said, she was just as nosy as we were. You could tell. I mean, she just kept like fiddling with stuff within the case. She kept, reading the different briefs and looking at the motions and things like that, just to be able to have an excuse for leaving it open so that she could watch what was going on. Two, 4, 601. And whoever got that, I love you. Well, he is very cognizant of the fact that people are watching the hearings. Same as Judge Middleton. Judge Middleton actually got in some pretty serious doo-doo at the beginning of Zoom hearings. It was like national news. Judge shuts down Zoom hearing amid something. Yeah. Judge Middleton determined that there was something that the public didn't need to see. I don't think he's turned a hearing off since because he got in big trouble for it. Because the courts are supposed to be open to the public no matter what. Absolutely. I love Les Mis. It's nearly my favorite. Yep. Yeah, Judge Middleton. I saw the article about it. I saw there was a news video about it. Guys, I took my meds, okay? My brain is not functional right now. I can barely make sentences out that make any sense right now. And my mouth is super dry. I keep finding myself saying words that are not words. I'm pulling Jerry's here. Oh, I know. Oh my gosh, that made me so mad. Oh my gosh, don't interrupt me. I get irritated when people interrupt me. Excuse me, ma'am. They're loading him on the stretcher. He might be in a little bit of a hurry. I'm gonna. You guys do this to me all the time. You pull me back in. I'll be like, all right, I'm gonna go. And then this one freaking hair that keeps going on my neck is driving me nuts. It's static electricity. It keeps like zoom right across my neck. I hate this. Oh. See, I gotta at least look fairly decent for the closing greeting because it's gonna be on all of the Replay Crew minis. So yeah, I try to do a really quick fix right before I do the closing greetings. And there's so much static electricity right now that it keeps like sucking my hair back under my chin. It's gonna make me look like I got a beard. I don't want a beard. I'm not that way. Oh, I love it when you lie to me. Oh, I love you guys so much. You guys are so great. I can't even tell you how much fun I have when I'm here. All right, I gotta wet my whistle before I say my greeting or my closing. Thanks again for coming out. And I will see you guys very soon. Be safe, be well, sleep sweet, and much love.